Under Maryland Criminal Code Section 4, 203, individuals are generally prohibited from wearing, carrying, and/or transporting a handgun on their person. Both concealed and open carrying may violate the statute unless one of the many exceptions to this general regulation applies to you. Exceptions include law enforcement officers, United States Armed Forces personnel, correctional officers, and wardens. At correctional facilities, individuals permitted under Title V, Subtitle 3 of the Maryland Public Safety Article. Exceptions also include individuals transporting a handgun, to or from the place of legal purchase or sale or to or from a bona fide repair shop, or between bona fide residences of the person, or between the bona fide residence and place of business of the person. If the business is operated and owned substantially by the person. If each handgun is unloaded and carried in an enclosed case or an enclosed holster. Individuals in Maryland are prohibited from wearing, carrying, and/or knowingly transporting a handgun in a vehicle traveling on a road or in a parking lot used by the public, on a highway, on a waterway, or on a Maryland airway. If you are arrested, you may face additional charges if you violate either of the above regulations, while on public school property, with the deliberate purpose of injuring or killing another person, or with a handgun loaded with ammunition. Violation of Section 4, 203 is a misdemeanor, which carries serious consequences. A Maryland gun lawyer can help you better understand the charges against you and potentially avoid conviction based upon the facts of the case. Depending on prior convictions, those found guilty of Section 4, 203 violations face various penalties, including imprisonment ranging from 30 days to 10 years, and fines ranging from $250 to $2,500. If the defendant has not previously been convicted under Section 4, 203, Section 2, 204, prohibiting the use of a firearm in the commission of a crime, Section 4, 101, wearing or carrying dangerous weapons, or Section 4, 102, deadly weapons on school property. The penalty is not less than 30 days or more than 3 years imprisonment, or a fine of $250 to $2,500. If the violation occurs on public school property, the minimum sentence is increased to 90 days imprisonment. If the defendant has previously been convicted once under Section 4, 203, Section 2, 204, Section 4, 101, Section 4, 102, Section 4, 203, or Section 4, 204. The penalty is not less than 1 year or more than 10 years imprisonment. However, if the violation occurs on public school property, the minimum sentence is increased to 3 years imprisonment. If convicted more than once before, the penalty is not less than 3 years or more than 10 years imprisonment. However, if the violation occurs on public school property, the minimum sentence is increased to 5 years imprisonment. If the violation was committed with the deliberate purpose of injuring or killing another person, the minimum is increased to 5 years. A Maryland gun lawyer can argue the facts of your case to secure a sentence at the lower end of the applicable sentencing guidelines.